Hello, good evening, welcome. My name is Kathleen Winters, and I'm the Executive Director for the Northern District Historical Society. Thank you so much for joining us tonight, both in person and virtually. Special thanks to our law firm co-sponsors for tonight's program, Bartco Pavia and Leaf Cabraser, Hyman and Bernstein. And we would also like to acknowledge Nancy Nishimura and Joe Cachet for their generous donation of the wine for the post-program reception. Our co-sponsors and our individual and law firm members make this event and others like it possible. We are also grateful to Court IT Head Stephen Curl, the Federal Marshals, and the 450 Golden Gate custodial staff for their help this evening. And as with all our programs, Alex Murray, over there in the corner, took care of countless details behind the scenes. Thank you, Alex. A few reminders: if you registered for CLE for tonight and you're here in person, please be sure to sign the CLE attendance sheet before you leave this evening. For virtual attendees, we will note your attendance online. And then finally, if you have not done so already, please silence your cell phones. It is now my pleasure to hand the microphone over to moderator Lee Brand, who will introduce our stellar panel. Lee is a partner at Pillsbury Winthrop Shaw Pittman, where his practice focuses on antitrust and consumer protection matters. He is current chair of the Antitrust and Consumer Protection section of the California Lawyers Association. Lee, many thanks to you and our panelists for being here this evening.
Thank you, Kathleen. Thank you, everyone, for joining us tonight. I'm going to start by introducing our very illustrious panel, although I think you're all probably pretty familiar with them, so I will keep it brief. But to my immediate left is the Honorable Fawn R. Walker, who served for 21 years on the federal bench here in the Northern District, including 7 as chief judge before transitioning to private alternative dispute resolution practice. Next to him is the Honorable Susan Y. Ilston, who was appointed in 1995 to the Northern District bench and has served on as the judge in many important cases, including TFT LCD, which is near and dear to our hearts, and I believe she will be discussing later on. Before that, practiced at Kitchett, Ilston, and Petrie. Next to her, we have Bob Van Nest, founding partner of San Francisco's Kecker, Van Nest, and Peters, and a preeminent trial lawyer both here in California and nationwide. Next to him, we have Tom Green, who is our voice of the government, has had the distinction of serving leadership roles in the California Attorney General's Office, the Federal Trade Commission, and the Antitrust Division, where he currently serves, as well as an adjunct professor at the UC Law SF. And I assure you, Tom's opinions will be his own and no one else's. And finally, last but not least, we have Brendan Glacken, who is another accomplished trial lawyer at Leaf Cabraser, heads their antitrust practice. So thank you so much to our panel. And I am going to begin with Professor Green, who's going to root us in the history of antitrust here in California.
Thanks, Lee. Hello, everyone. Welcome. Thank you for turning out of this evening. So my job here is to set the stage. So I'm going to talk a little bit about antitrust law and what it is and some of the procedures associated with that. And then I'm going to tag up on some of the history, which is really quite remarkable for this district. We are a center of excellence and I think a unique part of the topography of antitrust nationally. So let me start with the usual disclaimer: the views I express today do not necessarily reflect those of the U.S. Department of Justice. So with that done, let's turn to a brief overview of the antitrust laws. We in this district have a cornucopia of laws that we deal with that broadly go under the rubric of competition laws or antitrust laws. Firstly, at the federal level, federal law, the classic statute is the Sherman Act. Section 1 deals with combinations and restraint of trade. Think of, price fixers in a smoke-filled room deciding on the price of railroad transportation or something, or divvying up markets. So that's section 1. There's a plurality requirement, 2 or more people or firms are required. Section 2, this is a little odd how they numbered this, deals with what's called single firm conduct, monopolization, and attempted monopolization. Think of cases involving, say, Microsoft or Google. Those are section 2 cases. We also have the FTC Act, which actually has something called the fairness or unfairness standard that incorporates by reference or incorporates conceptually section 1 and section 2, and arguably there's arguments about this all the time about how much more that standard includes, but it certainly includes sections 1 and 2. And then finally, this district also handles a number of merger cases that is covered by section 7 of the Clayton Act. And so we've got this tableau of statutes. Violations of section 1 and section 2 can be enforced criminally or civilly. So I'm going to talk to you a little bit about both. Criminal sanctions include incarceration. People do get serious sentences. We just did a case involving somebody actually in Reno, a 40-month sentence for wage fixing of the wages of nurses. So it's not something that is not done. These penalties are slowly inching up. So incarceration and criminal fines, the fines can be quite large. Civil remedies include treble damages, remedial injunctions, and awards of attorney's fees. So that's the broad brush of the statutes and the remediation that's available under them. A few words about criminal practice. Those of us that had the opportunity to be prosecutors deploy a vast and amazing, from my perspective, toolkit. If you use a grand jury, you can do, well, and you are prosecuting, you get these from a judge, search warrants, grand jury subpoenas, grand jury sessions with witnesses, use of skilled investigators. In our case, it's typically the FBI that helps the Antitrust Division. So those are our guys. But one note here, even in civil investigations, just to jump the tracks here slightly, the division, the Federal Trade Commission, and the California Attorney General's Office have pre-filing discovery. So there are things called civil investigative demands. Some of you have responded to them, I know, and those are for both documents and for testimony. So the public agencies, all of which are within about a mile of this location, and in our instance, the Antitrust Division is about 5 floors away, we all have this power to seek information to build cases rather than getting a tip and then filing a complaint. Prosecutors also have the capacity to provide early relief to incent people who've participated, particularly in bid rigging or price fixing schemes, to come in and have a serious conversation with us. And that goes back, the current system was really created in 1993 with the Leniency Plus program. One of the people who's always been one of my heroes, Gary Spradling, who was the chief of the Antitrust Division, really was the pioneer for the Leniency Plus program. That led to a skein of cases built around people coming in to cooperate and helping us get not the bad guys, but the worser guys is kind of the point of this kind of thing. This system created a set of incentives so that people were incented to come in and come in early. They're mandated under that set of 1993 guidelines and the current guidelines to be completely candid and forthcoming. If they're not, they don't get the things that they want, which is basically a reduction in sentence or a decision for us not to file a criminal complaint against them. The initial payoff from the use of those guidelines of that Leniency Plus program was a series of cases involving commodity chemicals, guilty pleas, significant criminal fines, and a bolus of subsequent civil class actions for the people that were paid more. So they were So the criminal practice actually leads to a substantial amount of civil practice. After that, some cases that I know Judge Ilston and others will be chatting about involve the commoditized electronic parts cases, and that includes things like LCDs, DRAM, capacitors. All of those cases led to very large criminal fines. They also led to very significant class actions and civil recoveries. More recently, the division here has brought cases against local bid riggers. Pretty much all of the foreclosure auctions in the Bay Area, actually all across this district, were rigged. So we prosecuted at least 30 of these people, all of whom served some amount of jail time. They also paid financial penalties. We got the most press most recently on our packaged seafood criminal activity. So that's basically was a price fixing scheme involving canned tuna. So folks who buy canned tuna at hopefully a discount, they were affected by this particular deal, and we accepted plea deals and then tried to verdict a CEO of one of the companies who thought he was an organizer and thought he had done the right thing, which we disagreed with, obviously. That was also followed by follow-on civil cases. Most recently in 2025, this is a little bit of an experiment. That's not to say that we don't experiment sometimes on the criminal and government side, but the Antitrust Division just announced a whistleblower rewards program. This provides basically, it's kind of like a False Claims Act sort of thing. So the people who come in, this is for individuals only, not companies. Individual comes in, they bring to us information and evidence about a conspiracy. They can get up to 15 to 30% of the resulting criminal fines. So it creates a very direct and potentially quite substantial incentive. This is early days. Some of the early applications are interesting. There's one little footnote to this, which is our authority for this comes from the Postal Act, U.S. Postal Service. So it has to affect the Postal Service. Pretty much everything affects the Postal Service. That's what we are kind of saying in our public documents. But if you have an interest in this, there's actually quite a good website just to be aware that there is this new potential for people that want to cooperate to come and visit with us and help us out. One of the things that is sometimes a surprise to newbies in this district is how important state court law is, or state law is. And that aspect is sort of driven by the fact that California's Cartwright Act, named for Senator Cartwright, originally from Fresno, 1908, classic state antitrust statute. That statute is actually more consumer friendly than federal law. And in a particular way, it's way better than federal law. So just to put this in some context, there was a federal US Supreme Court decision called Illinois Brick, which basically said, okay, you got the smoke-filled room, the guys are there, they're fixing prices. If somebody buys directly, that is directly from one of the guys in the room, that's called a direct purchaser. Under federal law, they get a remedy. However, if one of the purchasers resells, which is typically what one does with a product, to the next person in the chain of distribution, they get nothing. Zippity doodah. The California legislature did not react well to this. So California, pretty much within a year after that decision was made, changed California's Cartwright Act to provide what is called an indirect purchaser remedy. So the next people down the chain of distribution have a remedy under California law. Let me just briefly talk about an example. So this law was sustained in a Supreme Court decision, California versus Arc America. Client was Caltrans. So we were dealing with a cement conspiracy. So cement manufacturers were engaged in a price fixing scheme. They sold their cement to contractors that were selling Caltrans bridges and roads. there is literally, if not more, a boatload of cement in any one of these roads. Caltrans was an indirect purchaser, would have had no remedy under federal law, did have a remedy under California law. And that was sustained in 1989 in that particular case. So that has led to a number of indirect purchaser claims being a staple of this district's workload. Because of CAFA, all these state claims are being swept, except for the parents' claims of the state AG. They're all being swept into this federal district court. And so this is an ordinary part of the business here. But I think hopefully we'll be able to illuminate this. One of the most brilliant production products of this court's analysis was Judge Ilson's decisions in terms of how you actually work your way through management of direct and indirect class action claims and make it work. So just brilliant work and very important to the public. That has literally brought billions of dollars to consumers here in California. Looking forward, California law is evolving. There's something called the California Law Revision Commission. The Law Revision Commission is the unit that is sort of the resource for the California legislature to generate new, very large pieces and significant pieces of legislation. That particular commission has now recommended to the legislature that there should be a new monopolization provision in the Cartwright Act and a new anti-merger provision, neither of which exists today. So we may see yet more interesting state federal aspects of antitrust world coming to play, actually in courtrooms just like this or just down the hall from where we are right now. With all of that, let me turn to a data point, which I think is true. I was a little surprised when I found it. So 2024 Lex Machina report says that this district, the Northern District of California, is where more antitrust cases are filed than anywhere else in the United States. More than New York, more than New Jersey, more than Eastern District of Virginia. This is the place to be if you are an antitrust litigator. And that has been by and large true for the last 20 to 30 years. In some years, others are close or have beaten us by like one or two cases, but most of the time, more cases are filed in this district court than anywhere else in the United States, which I think is a really big deal. But I think the part of this that is interesting is that this has this excellence, this reputation for excellence. This is the court where you want to go, is really based on a lengthy history of just extraordinary work by lawyers, judges, academics. So I think that just one theme I'd like to touch base with here and suggest that maybe we could visit with a little bit more. We have a tradition and a history of strong advocacies on both sides of the aisle. We've got some of the best plaintiffs lawyers in the country here. We've also got some of the best defense lawyers in the country here. And you better bring your A game to the courtroom because you're going to be facing really good people on the other side. The other, I think, is the existence of local offices of the division, the FTC, and the California Attorney General. They are developing cases. They're using all those powers that they have under their criminal and civil statutes to investigate and create cases. So that's a big part of it. We also are blessed with strong local antitrust scholarship. I mean, we have amazing antitrust professors. We have amazing antitrust economists. They are literally a cab ride away. And so that is a big part of this ecosystem is what I think about. And I think most importantly, not to blow smoke here, I think the most important thing is the thoughtful judicial management of important cases. I mean, we have really good judges here, and many of them have experience directly as litigators, but they also just take on the work of these complex cases. Let me just briefly touch base on what I think are some of the more interesting historical cases. I'm so glad that Joe is here because I started in 1959. Joe Alioto, who will become mayor in San Francisco, adjusts his business model so that he represents small guys, one of whom was a small business called Clores Appliances. It was a discounter on Mission Street doing a battle with a major department store. And Joe takes that all the way to the US Supreme Court and wins. So that's 1959. In 1965, in a case called Gray Line versus Gray Line Sightseeing, future federal district court judge William Schwarzer, won a summary judgment for a plaintiff, surprisingly, challenging a non-compete agreement amongst tour operators. In 1971, in Wall Products versus National Gypsum, this is a slightly more recent case, plaintiff giant Fred Firth, one of the great personalities of all time, won a price fixing case against wallboard manufacturers with defendants represented by the legendary Morris Doyle. And this case features, I had the opportunity to read the opinion recently, and the analysis by Judge Zerpoli is just textbook great. So we've got advocates, we've got judges, it's all there. In 1977, in Continental TV versus Sylvania, Lawrence Poposky, who's one of my favorites, but no longer with us, sadly, represented Sylvania in a case brought by Continental TV, which was a Northern California local discount appliance dealer. He ushered in a new era of antitrust analysis with his win in the US Supreme Court. In 1993, California versus Hartford Fire Insurance was decided in the Supreme Court. This was a case brought by a first ever multi-state coalition, which led to clarification of the McCarran-Ferguson Act, scope of the exemption for insurers, and more importantly, the scope of US antitrust law vis-a-vis cartels that were hatched abroad. That will subsequently be modified by something called the Foreign Trade Antitrust Improvements Act, which is an odd statute, I must say, but this is the one that made it clear that if you hatch a conspiracy and aim it at the United States, we can go after you. That turned out to be something that helped us with LCD and DRAM and all the other things. Finally, just to, note a criminal case in United States versus LG Display, 2008, LG Display, Sharp, and Chunghwa Picture Tubes pled guilty to antitrust charges and paid a $585 million fine. So my takeaways from all of this is that first, the Northern District antitrust cases have been getting larger and more complex over time. I mean, that's a clear arc when you look at the history here. The other is that this very unique combination of quality judges, thoughtful advocates on both sides, and local academic support have created, I think, a unique antitrust ecosystem in the Northern District of California, and lucky for us. With that, Lee, I'll turn it back to you.
Thank you so much, Tom. Thank you for taking us all the way to the 2000s and for mentioning the beginning of sort of the big tech era with LG Display. But before we get too far into tech, there were a couple of cases that were tried right here in the 2000s in front of Judge Walker that involved products that actually existed when the Cartwright Act and the Sherman Act were enacted. Well, one of those was about newspapers, and one of those was about tableware. And I think Judge Walker is going to share some of his experiences from those trials here in the Northern District.
Thank you, Lee. My assignment is similar to the assignment of Eclampus Vitus. You may know that Eclampus Vitus is an organization that celebrates the glories of the Old West, whether mythical or otherwise. And I'm serving as sort of the Eclampus Vitus speaker for the antitrust cases in this district. And the two that I'm going to talk about are two cases that I tried as a judge. And in both of those cases, the lead plaintiff's lawyer was none other than Joseph M. Alioto, who's here in the front row this evening. Undoubtedly here to be sure that the record is kept straight. And secondly, he should know, however, that any objections are going to be overruled. My assignment, as I said, is to describe these cases. And as Lee pointed out, one of them involves newspapers and the other fine tableware. Now, those products are pretty passé in the present environment of antitrust, dealing with high technology products. But the issues involved in those cases have resonance with issues that are very much alive today. Newspapers first. A little history is helpful. Until about 1959, there were 4 daily newspapers in San Francisco: the Chronicle and the Examiner, owned respectively by the DeYoung family and the Hearst family, both morning papers. In the afternoon, there was the Call Bulletin, which was owned by the Hearst Company, and the News, which was a Scripps Howard newspaper. In 1959, Hearst bought the News, and so the number of papers was reduced from 4 to 3. But from 1959 until about 1964-65, both the Chronicle Company and the Hearst Publishing Company were losing substantial amounts of money on these papers. And so they entered into what is called a joint operating agreement, in which the business end of the newspaper business was combined in a separate entity that was 50% owned by each of the 2 companies, and managed circulation, advertising, and all the delivery, all of the business ends of the business, and yet kept the 2 papers as separate editorial products. The wrinkle in this was that the Chronicle kept the morning field to itself. The Examiner, the Hearst paper, kept the afternoon field to itself, and the Sunday paper was published under the Examiner masthead, which created kind of an awkward situation. A 7-day subscriber to the Chronicle would receive the Examiner on Sunday. Now, that had some of the features of the Chronicle as an insert, but it was a different product. The Sunday paper was different from the daily product. That was not the only oddity with the arrangement that existed under the joint operating agreement. And by the way, several other newspapers around the country were parties to these joint operating agreements. It was quite a common arrangement in the mid-60s, up to the mid-60s. In 1969, I believe it was, a case argued by my former partner, Dick McClory, in the Supreme Court, found that these kinds of arrangements were violations of Section 1 and Section 2 of the Sherman Act, as Tom has described. And that put an end to the idea of the legality of these joint operating agreements, but the existing agreements were grandfathered in, including that of the San Francisco joint operating agreement between the Chronicle Publishing Company and the Hearst organization. But the real problem here was that the profits of the enterprise were split 50-50, which created a disincentive to improve the quality of the product. Every dollar invested in improving the quality of the newspaper earned only 50% of any resulting profits, which created an incentive for Hearst, because Hearst had the evening field. And from about this time until the demise of evening newspapers generally, evening newspapers essentially disappeared around the country. And the circulation of the Chronicle in the morning field stayed pretty much at the $500,000 mark that it existed prior to the joint operating agreement. But the Examiner in the afternoon field slowly eroded away, so that by the end of the period in the late 1960s, it had gone from about $400,000 or 400,000 circulation daily to just a little over 100,000 daily circulation. So, but the profits still inured 50% to the Hearst organization. Well, the term of the operating agreement was 30 years. Hearst Hearst exercised an option to keep the joint operating agreement in place for another 10 years. Chronicle in late 1999, I believe it was, announced that it was going to not exercise its right of first refusal. So the parties were looking at the end of the joint operating agreement, and they had to do something about it. The Hearst organization was much more financially well off than the Chronicle organization. They hired investment bankers and went to negotiations and ultimately came up with an agreement to buy out the Chronicle, pay off the descendants of the DeYoung family, which owned the company, and merge the paper into essentially one newspaper. There was another wrinkle, however. The witch's brew of local politicians, wringing their hands and gnashing their teeth, decried the loss of the Examiner, the loss of an independent editorial voice in the Bay Area. And this led eventually to the witch's brew recruiting a substitute for the soon-to-demise Examiner in the form of a throwaway newspaper that was operated by the Fang family. And to the Fang family was given by the Hearst organization the masthead of the Examiner, the intellectual property, and many of the features of the Examiner, and interestingly enough, a $66 million subsidy to take the Examiner off the hands of the Hearst organization. Well, that brought forth Joe's client, Clint Riley, a retired political consultant, someone who's, of course, quite familiar with the witch's brew of politics. And he brought an action to enjoin the transaction. And Joe entered an appearance on Riley's behalf in the case. As I said, the joint operating agreement, for the reasons I mentioned, was inescapably troubled, leading me at one point to observe, seeing the demise of the quality of the Examiner over the years, that it was better dead than red. And the politicians came to the fore in all of this. And so Joe is characteristic in his antitrust cases to bring forth his first witness was the publisher of the Hearst-owned Examiner. It's always a good idea to call your opponent as your first witness if you possibly can, and Joe does this. And so he called to the stand on the first day of trial the publisher of the Hearst-owned Examiner, who testified about this witch's brew of politics that led to the negative price that was paid for the Examiner assets. And never one to overlook a fly in the ointment. This witness testified that he had offered favorable coverage in the Examiner to this witch's brew of local politicians if they would support Hearst's acquisition of the San Francisco Chronicle. Well, Joe brought that out at just shy of 5 o'clock on the first day of trial, when we were scheduled to adjourn. And it was like a bomb had gone off in the courtroom. I wondered all day, all night, the rest of the day and night, how Hearst was going to rehabilitate this guy. And of course, at the end of his examination, Joe had, with flurry, tendered the witness for examination, actually direct examination. In any event, the next morning, Gary Halling, representing the Hearst Corporation, wisely stood and said, "Your Honor, no questions. He was relying on the fact, and I think he was wise in doing so, that the evidence in the case would show the impracticality of keeping the Examiner alive as a separate, wholly owned newspaper. So the case went to judgment, and it was a case in which, at the end, everybody won. Hearst won because it got the deal. It got the newspaper that it wanted, the Chronicle. And we found, on the basis of the exposure which Joe had brought to the political witch's brew, as I've described it, the local politicians getting into the act, and the Department of Justice, too, had a little few fingerprints in things at this time. Bringing this out provided a basis for awarding Joe his attorney fees, notwithstanding the fact that he'd lost the case. So everybody, and Hearst was so delighted to get the Chronicle and end the case that they paid those fees. Several years later, at a social event in New York City, I met Frank Bennick, who was the head of the Hearst Corporation. As he extended his hand out to greet me, said, "All is forgiven." And indeed, it was. Well, everybody won in the case on both sides, which is an unusual outcome in an antitrust case or indeed in any other case. So that brings me to the second case, the tableware case, in re tableware antitrust litigation. This was an action brought on behalf of customers of fine tableware. There were both vertical arrangements and horizontal arrangements. The vertical arrangements were pretty problematic to survive an antitrust test. And consequently, the manufacturers of fine tableware, which are china and crystal and flatware and so forth, they were eliminated from the case. But the case went to trial on the basis of the horizontal arrangements between the two department stores which sold tableware in their shops, their stores. They had entered into horizontal arrangements to preclude specialty retailers, particularly Bed Bath & Beyond, which has gone through bankruptcy in recent years. But in any event, at the time, it was considered to be a threat to department stores. And the department stores were worried about this desirable product being sold in specialty retailers. And there's certainly some evidence to support that concern on the part of the department stores. And of course, Joe made as much of that as he possibly could. He had, for example, as his first witness, the CEO of Federated Department Stores, a fellow by the name of Terry Lundgren. And Lundgren had written the letter, which Joe had up on an easel in the courtroom. We read that letter up and down, sideways and around throughout the entire trial with every witness. It was what Alfred Hitchcock used to call in his movies a MacGuffin. It was something that drove the action in the story, but ultimately didn't amount to very much. And yet it was relied upon at every turn in the witnesses and in the processing of the case. But the fact that it really was a MacGuffin was displayed when Joe, in his closing argument, going to the letter, pointing out what it said this way and that way, quoted from the Rubaiyat by Omar Khayyam. The moving finger writes, and having writ moves on, and all thy yesterdays, all thy tears will not wash out a word of it. Of course, the department stores were walking away from that letter at every possible turn. I knew that Joe was in trouble when he quoted the Rubaiyat from Omar Khayyam. One of the jurors, juror number 2, if I remember correctly, looked up at me at that point and just rolled her eyes, showing that the evidence in the case didn't quite match the rhetoric that was brought to bear. In any event, the case foundered on lack of evidence and coordinated conduct by the department store defendants, and no amount of eloquent lawyering and good preparation can be a substitute for evidence that's missing. Now, let me just tie a bow, if I can, on Tom's presentation about antitrust cases. Not only is the Northern District of California the preeminent district in bringing and processing antitrust cases, antitrust cases also gave rise to multi-district litigation. In the latter part of the Eisenhower administration, a series of antitrust actions were brought against the manufacturers of electrical generating equipment, which Joe's father was prominent in those cases. And ultimately, that led to a series of private damage actions under Section 4, I believe it is, of the Clayton Act. And there were something on the order of 25,000 of these cases in the district courts around the United States, threatening to close down the federal courthouses around the country. That was the moment. But the moment met its man in Chief Justice Warren, who came to the Supreme Court of the United States with not the kind of academic or court of appeals background that most justices now come to the court with, but with very keen political skills. He began as a line prosecutor in Alameda County. He became district attorney of Alameda County. He was elected state attorney general. He was elected governor of California 3 times, twice essentially uncontested, because he appeared on both the Democratic and Republican lines. He was the Republican nominee for vice president in 1948, a serious contender for the Republican nomination for president in 1952. And so he came to the court with keen political instincts and an ability to size up people and their interests in a way which he displayed very early in his Supreme Court career with Brown versus Board of Education, converting a case that had been very much of a split decision into a unanimous decision. And when this flood of antitrust cases was threatening to shut down the federal courthouses around the country, he put together a committee of the Judicial Conference to deal with this situation. And that experiment led ultimately to the enactment of Section 1407 of Title 28 and the creation of the Judicial Panel on Multi-District Litigation. And it turns out that of the districts around the country, not only is the Northern District of California preeminent in antitrust litigation, it's preeminent in multi-district litigation. Presently, there are 18 multi-district dockets in this district, more than any other district, more than the Southern District of New York, the Eastern District of New York, the Eastern District of Pennsylvania, Eastern District of Michigan, Northern District of Illinois, name them all. And this district has more of those multi-district dockets than any other. And the other remarkable thing about that series of multi-district dockets in this district is that unlike some of the districts, which have a flood of cases, primarily the pharmaceutical personal injury cases, there are a few of those here in this district, but the variety of multi-district cases in this district is really quite striking and is unlike, I think, any other district in the country. So antitrust has continued to create a lot of business here for the lawyers and judges in the Northern District of California, but has also contributed to a growth of multi-district litigation, in which this district is also preeminent, and the judges of this district have proven that whatever the multi-district panel can throw at them, they're able to handle very well indeed.
Thank you, Judge Walker. Turning to the tech industry now, and to another way in which I think this district has led the way. There's been a huge development in recent years in the labor side of antitrust. Antitrust claims, criminal, civil, and labor markets. But one of the earliest cases in that space was INRI high-tech employee antitrust litigation. And we are lucky to have both sides of the V from that case on the panel. So Brendan, plaintiffs first. Can you tell us a little bit about that case?
Yeah, sure. I'm happy to. Good evening, everybody, and thanks for having me. It's an honor to be here. So my name is Brendan Glacken. I'm at Leif Cabraser, Hyman and Bernstein, and it was our case that filed, our firm that filed the initial civil damages case in the high-tech litigation. So I'm going to tell this, since this is the Northern District Historical Society, I'm going to tell the story of how that came to be. It was back in 2010, 2011, and we, the plaintiffs' bar, were sitting around doing whatever it is we do. I was busily litigating the LCD's case along with other people in this room, and on our various news sources, there dropped the information that the Federal Trade Commission had filed a complaint and a consent decree and an injunction against 7 of the biggest, most important technology firms in the Bay Area. And the complaint alleged that these firms had, in a nutshell, agreed not to cold call each other's employees, not to call into the employees of the other firm to try to actively recruit them for jobs at their firm. And so, of course, we, the plaintiffs' bar, globally across the country, because it's what we do, we looked at this and we thought about, well, this is interesting. This is fascinating. These are 7 great big companies that can pay a huge judgment. And the FTC has gotten some injunctive relief here, but what about the damage that these agreements caused over the years? And we, the plaintiffs' bar, looked at this and said, no way can we do this. There is no clear path to proving impact on a class-wide basis in a case like this. How are you ever going to know who it was that didn't get the call and didn't get recruited? And we don't even know if the standard here is per se or rule of reason. And if it's rule of reason, we're out of luck because of labor markets. There was one lawyer. To my knowledge, many years later, there's only one lawyer in America, plaintiff's lawyer, who had a different opinion, and that was my partner, Dean Harvey, who was at the time was an associate. Dean believed passionately that this case could work. And he spent, while I was off litigating LCDs, spent the better part of a year trying to figure it out. He called expert economist after expert economist. Many of them told him it would never work, and he didn't talk to them anymore. But he ultimately, developed a theory of how this could be done, and he persuaded me, the chair of our practice group and leadership of our law firm, that this was a viable case, even though nobody else seemed like they were interested in doing it. So we brought the case, and the case was against 7 very large technology companies: Adobe, Intuit, Intel, Google, Apple, Pixar, and Lucasfilm. And it featured some very spicy emails among some very notorious figures in the technology industry, including Steve Jobs, Eric Schmidt, Brin, Page, the whole kit and caboodle, so to speak. There were 3 problems that we had to sort of address in that case, or I should say 3 challenges that where there wasn't a clear answer, that we sort of had to figure it out. We were really figuring it out for the first time. So one was this question of, is this a per se or rule of reason case? We felt in our bones it had to be per se illegal for 2 companies to agree not to compete for their workers. I mean, it was one of these things that seemed so obvious it had never been written down in a case decision anywhere. But nevertheless, it was not written down in a case decision anywhere. But we believed it was true. And we litigated the case on the basis that it was a per se violation. We were ultimately proven right by the 7th Circuit and the McDonald's franchise no poach litigation. We never got the answer from Judge Koh. The case settled before that question was briefed to her. We briefed it in the context of what the instruction would look like. But she did not have to decide it because we settled the case. The second challenge was the evidence. There was strong evidence of many bilateral communications among these esteemed titans of industry But it's not like they ever sat down in a room together and decided to do this. And so we faced the challenge of establishing that this was a single conspiracy, a single agreement, rather than a series of individual agreements tied to the discovery record that existed about individual one-off communications. And to get there, we relied on the fact that all these people know each other. One of these gentlemen, Bill Campbell, God rest his soul, who was the CEO of one of these companies, was also like the life and professional coach to 3 of the other CEOs. You know, they were not strangers to one another. Our evidence or our case was going to be that they operated essentially like a club in Silicon Valley. They all knew what was going on, and they just viewed this not poaching each other's employees as a sort of moral code amongst the brotherhood. That was going to be our case if we ever had to try it. But it was a challenge, given that the evidence, the documentary evidence, was solely one-off emails between Steve Jobs and Eric Schmidt, or Steve Jobs and Sergey Brin, or et cetera. And then the third big challenge on the economics front was the challenge I alluded to at the beginning, which is the defense case was, hey, the only people who were harmed here were the people who didn't get the call. We'll never know who they were because they didn't get the call. So, haha, gotcha. No class. So we developed a theory that is, theory in the sense of a scientific theory that it's true, which is that companies set their pay structures in a way that relates the compensation of the workers, right? Companies don't approach each individual worker as a snowflake. They set a pay structure that maintains a concept of internal equity among the various employees at the firm. So their compensation is tied together. And a force that affects the pay structure at any point is going to affect the pay of every employee in the firm because there is this force of internal equity. And so our argument was not that so-and-so didn't get the call. The argument was that knowing that no calls were going to be made freed the companies to pay their workers less. This is an argument that I don't think had ever been made anywhere ever, at least in lawsuits. But it was actually, it's got very strong foundation in economic theory. This is not insane. But then to prove this, Judge Koh was not going to take our word for it that this was correct. We had to develop, again, never been tried before, tools of econometric analysis to establish not just the quantum of damage, but also that this relationship we contended existed did in fact exist. So we ran multiple regression analysis on every job title at every single one of these companies in order to prove that the titles moved in a related fashion. And that was that combined with the strong documentary evidence was what persuaded Judge Koh on the second try, hearing from yours truly, that she actually ought to certify a class in the case. I thought that a trip to the Historical Society wouldn't be complete if I didn't share with you some of the evidence, which was, I already alluded to, lots of fun. Unfortunately, the case is, it's still under seal and it was never tried, but I do have the public version of Judge Koh's order granting class certification, which quotes some of this evidence. So one memorable moment was the deposition of George Lucas, who was represented by John Kecker, Mr. Van Ness' partner. And I believe the deposition was taken by Joe Saveri. I'm not certain. And Mr. Lucas was asked about, his views on the subject of, why it was that he and Pixar had agreed, he and Mr. Jobs at Pixar had agreed they're two companies. We're not going to try to recruit each other's workers. And he described the animation industry this way. He said, it's not a normal industrial competitive situation. He said, the rule we had, or the rule I put down for everybody, is that we cannot get into a bidding war with other companies for workers because we don't have the margins for that kind of thing. This is the only time I'm aware that George Lucas has ever pleaded poverty. And I don't think George Lucas knew what had happened on the class certification front in that moment, but I'm pretty sure that Bob's partner, John, knew what had just happened. We sure did. And I'm sure if George had known, he wouldn't have cared, right? So the other one, there were lots of emails involving Mr. Jobs, from Mr. Jobs. And one of the, and I think how this maybe came out, one way that this all may have came to light for the Trade Commission, I'm not certain actually, maybe Bob may know, is that Steve Jobs tried to recruit into this conspiracy Ed Colligan, who was the CEO of Palm. I don't know if you remember Palm. Like Palm made this like handheld computer thing that doesn't exist anymore. And they went back and forth in email. And Steve was writing to Ed, hey, listen, I'm really not happy that I've heard Palm people or, recruiters are calling into Apple and trying to recruit people from Apple, because Apple had the ultimately successful Newton device in its stable. And Ed Colligan wrote back to the effect of, no, like we're not going to agree not to do that. It's not fair. It's not right. He actually told Jobs it's probably illegal. And this was in like after 3 or 4 times of Ed Colligan refusing to go along, this is what Jobs wrote to Colligan. This is not satisfactory to Apple. We must do whatever we can to stop this. I'm sure you realize the asymmetry in the financial resources of our respective companies when you say we will both just end up paying a lot of lawyers a lot of money. My advice is to take a look at our patent portfolio before you make a final decision here. In other words, he's basically telling Colligan he's going to sue him out of business using Apple's patent portfolio if he doesn't agree to stop recruiting his workers. That's how passionate they were about this issue. Every single one of these guys, when we deposed them, just felt passionately that it was just wrong for anyone to try to call in and recruit their employees. So those are some of the memorable ones. I mean, it was a, I don't know, the case went on for years. I could sit here and talk for an hour, but we've got some other cases we need to get to. So unless there's something, and I'm not even going to start on the Lucasfilm federal enclave defense that was advanced by the Kecker Van Ness firm unsuccessfully. Unless someone wants me to address something else, I'm going to kick it over to Bob.
Yeah, let me just make a few comments. Thank you, Brendan. It's easy to talk like that when the case settles at the end, right? There was never a trial, and there's a reason for that. You heard about economics, you heard about legal theory, but those of you that try cases know it turns on a few critical facts. Now, early on, Lucasfilm, Pixar, and Intuit settled $20 million. That was the settlement for those 3. Our firm was asked to come in and assess with appropriate waivers, represent all 4 of the others: Apple, Google, Intel, Adobe. What are we going to do? The lawyers that have been representing them are very bullish. We got some strong legal defenses. We got some great legal theories. I said, guys, we got to do focus group. But this is going to be a jury trial. We need to do a focus group and see what's going to happen in this thing, right, guys? Because you can do legal theory, you can do economics, you can do econometrics, you can do all that. We had a very plaintiff-friendly judge, too, in Judge Coe, at least on this case, that's for sure. But I think Brendan underemphasized some of the evidence that actually the FTC had developed and was already available to the plaintiffs. So here's a few of these that went into the focus group. Now imagine you're a person, you're asked to do a focus group, it's a Saturday, and you're going to see video of George Lucas, Steve Jobs, Paul Otellini, Eric Schmidt. It's a good day. Your $300, you hardly even need it. Here was some of the evidence that we had. It's quoted also in what Brendan mentioned. Here's Eric Schmidt. He's asked by his head of HR, how do I popularize this with the recruiters? Well, Eric says in an email, quote, share the information verbally since I don't want to create a paper trail over which we can be sued later. Duh, okay. Paul Otellini running Intel, he's asked by his head of HR, what are we going to do? What do I have something I can rely on? I can send to the recruiters? Quote, we have nothing signed. We have a handshake, no recruit between Eric and myself. I would not like this broadly known, unquote. I'm not sure why you put that in an email. The capper was, Brendan mentioned Lucas. We can't get into a bidding war. Ed Catmull had been running Pixar, and they were settled, but of course their evidence still relevant. Ed's comment, quote, solicitation like this messes up the pay structure. Kids group, which was quite an experience. We showed all the video, we settled the case, and we moved on from there. But that was noteworthy because of the evidence that existed at the beginning.
Thank you both for those anecdotes. Brendan mentioned the federal enclave defense, which actually I thought was brilliant, which was maybe you want to tell it. It was ultimately, I think, unsuccessful just based on the dates, but it was based on the fact that Lucasfilm was in the Presidio, right?
I'm
not sure.
That's not fair.
I'm not sure.
Bob didn't hear about that until like 10 minutes ago. So the federal enclave defense is that a state law does not apply to conduct on federal ground unless the law that has been ceded to the federal government by the state, like a military base, for example, unless the law was in effect prior to the cession of the land to the federal government. So the Presidio has been in existence since 1897. The Cartwright Act was passed in 1907. And so Lucasfilm argued that because Lucasfilm is headquartered in the Presidio, it is immune from a lawsuit under the Cartwright Act. You see something new every day in this job. I mean, I remember.
If you read the order, it failed because the conspiracy started before they moved to the Presidio.
It started before because apparently a lot of bad things happened in Emeryville at Pixar with Mr. Jobs. So it failed for a few reasons, but it was creative and novel, and I enjoyed learning about it.
It's interesting marketing for the office space, the Presidio. But another labor case that Bob is going to talk a little bit about, and I think it's not a case that anyone thought of a labor case in its early stages, is the NCAA litigation that I know several folks in this room worked on, and was another important series of cases in this district.
It was. Thanks, Lee. We're running a little bit behind. I'm going to cover this very briefly. It's a remarkable series of cases handled in our district by Judge Wilkin that, of course, has changed the face of college sports forever. It's quite remarkable. It involved trips to the Ninth Circuit, trips to the Supreme Court, and so on. But the basic gist of it was that the universities were limiting what athletes could be given in terms of scholarships. And of course, they were prohibiting any pay to athletes. This case took 3 or 4 cases to get done. Very creative lawyering. Our firm represented Electronic Arts because they also sued the video game makers. Electronic Arts made Madden Football. We got out very early with a very low settlement. And as you'll hear, this case just kept getting bigger and bigger. So it started as the O'Bannon case that Judge Wilkin tried in 20. Ed O'Bannon was a basketball player at UCLA. And she certified 2 classes. She certified a college education class. That's colleges competing for athletes. And she certified a group licensing market. That's colleges competing in licensing. She tried the case. The focus of it was you're limiting scholarship money and there's basically capping the value of the scholarships. And you're forbidding athletes to get any money from their names, image, likeness, or their performance. Okay, so she found clearly a Sherman Act Section 1 violation across the board. She applied the rule of reason. Of course, the NC2A defense was, hey, we're amateurs. And that defense was what they wrote on. That was their business justification. It turns out the athletes prevailed as to the college education market, and Judge Wilkin found a violation. They didn't prevail on licensing. Why? Because she found, I think quite correctly, they're not in competition. If a broadcaster or a video game maker needs a license, you got to have the whole league. It doesn't do you enough to license Stanford or Cal or Washington or UCLA. You got to get everybody. So there is no competition. It's going to be one big license for everybody, which in fact was how Electronic Arts and the other video game companies had been proceeding. They had licenses with the whole league, and that's how they went down. Now, Judge Wilkin created two remedies. One was you can cap the scholarship money, but it's got to be at a reasonable number, the full value of education, and then some. And she said, you can provide cash compensation up to $5,000 per athlete. The Ninth Circuit struck that down. The Ninth Circuit affirmed the liability. It affirmed the remedy as to the scholarships, but it struck, remarkably and ironically, it struck the $5,000 on grounds that it was inconsistent with amateurism. Now, this is after Judge Wilkin had already found that that wasn't a good enough excuse. Now, at the same time, she was handling a separate case called Alston, which went all the way to the Supreme Court. Alston went right at salaries. They said, hey, the same thing is true. You ought to be able to pay athletes salaries. They're not being paid. They're still being very restricted on their scholarship money. That case went to trial. The class lost on the compensation for athletic services. The judge found that that was inconsistent with amateurism, primarily, I think, based on the Ninth Circuit's ruling in O'Bannon. And she permitted the NC2A again to limit scholarship money, but no extra money. That all went up to the Supreme Court. The Supreme Court affirmed it. Unanimous Supreme Court opinion. Justice Gorsuch said, I don't know what you mean by amateurism. There's so many different definitions, and we'll never know how this trial would have ultimately come out because, as you guys probably all know, reading the papers, there's been a huge global settlement. $2.6 billion is the settlement between the classes and the NC2A. That's going to be paid yearly over 10 years. And bigger than that number, it allows for athlete salaries up to 22% of the collegiate revenues. So experts are predicting that that's going to mean $20 to $32 million in salaries per school, per year, totaling something like $20 billion over the next 10-year period. That's what that's unleashed. So they're going to get a large amount of money for past damages, and now the schools, as we all know, can pay salaries starting next year. We now have the portal. College football has changed forever as a result of these cases. So they weren't trials. They were bench trials early on, but the big grand finale ended up in this massive settlement. That's NC2A cases.
Thank you, Bob. Another phenomenon, or maybe we could call it a witch's brew of globalization, of the amnesty program, of the reach of the FTAIA and flexibility perhaps of the FTAIA, is the rise of components cases in this district. And there is one case, I think, that had it all. Criminal trial, civil trial, direct purchasers, indirect purchasers, and Judge Ilston provided over those for many years. And she's going to talk a little bit about that.
Yeah, we'll talk about that. For those of you who are young, televisions used to be cubes. The bigger the screen, the bigger the cube. My case involved TFT, LCD, thin film transistor, liquid crystal display, the technology that brought us flat panels. It was developed, it became developed and started becoming commercial in the 1990s. And of course, very rapidly was just ubiquitous. It was in everything. It was in watches, it was in telephones, it was in computers, it was everywhere. So the case we had involved the manufacturers of LCDs, the liquid crystal displays, who were primarily Asian companies. It was primarily South Korean and Japanese and Taiwanese companies. It was a completely, to me, classic price fixing conspiracy. It was just really kind of sweet in its development. And looking around the room, I see so many of you that were involved in that case. So you're going to remember better than I all the details of it. But what struck me from the beginning about that case is that there really were two CEOs who met on a golf course one day. They were at the point where they were beginning to create larger factories to manufacture the flat panels. And the big factories are really expensive to build. And they were saying, you know, it would be really great if we could kind of stabilize prices so that we know that we will be able to recoup the investments, the massive investments that we're making in these fabs. And they decided that they should cooperate in making that happen. So they did. And the companies that were involved, there were 10 or 15, depending upon how you count them, companies that agreed that they would have basically monthly meetings, and they would have an agenda in writing for the meetings, and they would go over who had been selling how much and for what for each of these companies that was involved. And they sent a relatively junior person there. They did it in hotels with misleading signs. It didn't say crystal conspiracy this direction, it had misleading signs. But these in my mind, they were young persons, all went to these meetings, they had their discussions, they prepared minutes in writing. And then the minutes, when they took them back to their companies, they usually were sent off through the system so that there'd be little, check boxes to make sure that all the higher ups actually read and reviewed the minutes of the price fixing meeting. So it was just wonderful in its simplicity. Ultimately, and there was, this went on for a long time. We had a lot of trials. There was testimony that ultimately some young MBA came up to some CEO and said, I think we're creating a risk with what we're doing here, and we shouldn't do this. This was a time when the Antitrust Division had a robust amnesty program, and it was used, and the Antitrust Division got on it and began investigating and uncovered what ultimately proved to be the price fixing organization in the case. In the back of my mind, I always wondered if there was a cultural aspect to it. I don't know. I think they viewed it as cooperation and not conspiracy. But in any event, what they did was they fixed the prices. So people got into the amnesty program. By the time the dust settled, there were 10, plus or minus 10 corporations were indicted in this district. And they either pled guilty or were convicted at trial. There were 15 individuals at those companies who were also prosecuted. Some of them pled guilty, some of them were convicted at trial, some of them were acquitted at trial. Sharp, LG, Chunghwa, Hitachi, Epson, Hamstar pled guilty. AUO was the one that kept going to trial and kept getting convicted. And then that was such a great term, a bolus of civil actions, which followed on after the indictments. And I will say, when I was a lawyer, I felt, and I occasionally would preach this, that it would make much more sense if in the federal system, if there is a criminal proceeding, and if there are civil proceedings, the same judge should preside over the criminal and the civil, because it only makes logical sense. Well, be careful what you ask for, because that's what I got. And we got this massive, massive case, which was a lawyer's full employment act. I will say that, because all of the fabulously capable lawyers that there are in this community, antitrust lawyers, either had plaintiffs or the individual defendant, the corporate defendants, had individuals who had also been prosecuted. So of course you needed separate lawyers for all of those folks. So all the lawyers in town were busy on this, and it was that was one of the best parts for me, was that we had just so many really capable lawyers working together on this. So it was, I don't want to say it was a pleasure, but it was always very, very interesting to proceed. We had in the MD, and of course, there was an MDL in this case, the multi-district litigation decision, and we got cases from all over the country. There were 10 or 15 states that had parents patriae actions. There were direct purchasers. There weren't too many direct purchasers, really, because the flat panels tended to be incorporated in something that big companies then bought. So the Illinois brick issue having to do with indirect purchasers not being entitled to bring price fixing claims loomed large in this case. Not to worry, there's the Cartwright Act, and it turned out, and Bruce Simon was one of the lawyers in this case, and he represented the direct purchasers, I think, and he helped me yesterday by reminding me that we had cases from California, because these are all states that have the repealer statutes: California, Michigan, New York, Illinois, Minnesota. There were many of them had repealer statutes. So that got you to the direct purchasers. And many of you here, I mean, the indirect purchasers, many of you here represented those folks as well. That is where a large part of the money damage was focused, but it was complicated by the need to bring the action under the repealer statutes. There were parents patriae cases on behalf of 15 different states. Think about it. States buy so much that involves flat panel screens that the impact of the price fix was just enormous. The direct purchaser class went to trial against Toshiba and Handstar. It had settled with all the other defendants previously. So it had, of course, an agonizing choice to make, which is, if we're going to try this case, do we tell the jury about the other settlements or not? And there's pros and cons to all of that. But if you don't tell them, then you need to get a verdict in excess of whatever your settlements are in order to make any money. So that was an issue for the direct purchaser class, which ultimately decided not to tell the jury. So therefore, we had to fashion instructions telling the jury, well, there are other folks involved in this. Don't worry about them. That'll work out in the wash later on, or something like that. One of the opt-out, there were some of the large companies opted out of the class actions. One of them was Best Buy, and it tried its case to a jury, and that had mixed results as well. It tried its case against Toshiba and AUO. Toshiba, nobody ever really held Toshiba in, I think, on a jury verdict in that case. And AUO, but they prevailed against AUO. But in that case, we came face to face then with the question of the pass-on defense. In the federal cases, the pass-on you cannot, the defendants can't defend by saying, well, they had to pay more to us, but they passed that along to all the buyers downstream, and therefore they weren't damaged. You can't say that on a federal price-fixing claim. But in these other states, under which had Illinois brick repealer statutes, you can. So Best Buy, which of course is an enormous company, I made the determination, and this never was tested on appeal, so I don't know if it was correct, but I determined that that pass-on would be a defense. And so there were experts who could describe the various levels at which the pass on kind of trickled into the consumer community. But the bottom line was then Best Buy itself was able to avoid pretty much all of the impact of the price fix. So it was a disappointing result for Best Buy. Amusing anecdotes. They want us to tell amusing anecdotes. Well, one amusing anecdote was that as we tried these cases, they were mainly Asian companies, and the witnesses testified in a variety of languages. We had Korean, we had Mandarin, we had Cantonese, we had Japanese. And of course, we had well-heeled parties. So each party had its own interpreter. And then there was a court-appointed interpreter. So the court-appointed interpreter would interpret, but then if the parties' individual interpreters felt that it was an inappropriate interpretation, then they would all consult and confer, put their heads together and let me know. Sometimes the court-appointed interpreter would change and say, yeah, I think you're right, it should be. But there were classic instances where all three disagreed. Nobody agreed. And they said to me, we want you to do the interpretation. The jury loved that. Another amusing part, or not so much amusing, but black comedy, I suppose you'd call it, was the FTAIA, the Foreign Trade Antitrust Improvement Act. It is a statute that had not yet been used too much, so there wasn't a lot of case law on it. And the statute itself was opaque. I brought the language of it here so I could share it with you. Sections 1 and 7 of this title, having to do with the price fixing claims, shall not apply to conduct involving trade or commerce, paren, other than import trade or import commerce, close paren, with foreign nations, unless 1, such conduct has a direct, substantial, and reasonably foreseeable effect, A, on trade or commerce, which is not trade or commerce with foreign nations, or on import trade or import commerce with foreign nations, or B, an export trade or export commerce with foreign nations of a person engaged in such trade or commerce in the United States, and such effect gives rise to a claim under the provisions of Section 1 and 7. So,
Clear.
and for that, we had to construct a jury instruction, which we did. But I want to give a shout out to the American Bar Association Antitrust section, which for many years worked very hard to come up with model jury instructions. I don't think they ever took on the FTAIA, but they came up with a set of model instructions that was very helpful to me in all of the cases that we tried there. But the bottom line at the end, and this was a big number to me then. Overall, there were $1.103 billion in damages to purchasers, and in criminal fines there was $1.392 billion in criminal fines. So it was for the time anyway a really big case. But the pleasure for me was working with all the excellent lawyers that were involved in that case. There were just so many moving parts that there were lots of lawyers. So I had an opportunity to get to know many of you, and that was really excellent.
Thank you, Judge Ilston. And I know we're getting close to time, but if you'll indulge us for a little bit more, I think we'd be remiss if we didn't talk about the intersection of antitrust and IP in the Northern District. And if you can speak to that as well as Bob, and I think there's one case in particular he's going to tell us about.
Yeah, I want to talk very briefly about a very important case, FTC versus Qualcomm, and the consumer class action that followed it that many of you have been involved in. Qualcomm makes the chips in your phone that allow the data in the phone call to go through. 3G, 4G, 5G. They make the modems that the phone device makers like Apple and Samsung buy. They also have the patents on this whole protocol. standard essential patents. So they have two businesses. They sell the chips and they sell the licenses. And plaintiffs came along and the FTC and said, this whole business model is terrible. When you buy the chip, that ought to be it. You shouldn't have to pay a license too. You buy the chip, you're paying, that's it. Okay. So we were tasked with defending that dual business practice. And it's important because it's a Sherman Act and a Cartwright Act both. So Judge Koh made very clear on our motion to dismiss, we were going to lose the trial. So we knew that going in. And indeed, we tried for 2 weeks. We called all the brass at Qualcomm, plenty of experts. She issued a sweeping ruling that you cannot tack on both a royalty and the price of the chip. That's no good. She also said you've got to license your competitors like Intel and AMD, but they weren't willing to do that because they wanted to license the handset makers who were selling a $200, $400 phone, not a chip maker selling a $20 chip. So they refused to license them. They had a very lucrative deal with Apple, which they called a volume discount, but Judge Koh found an exclusivity deal, and Judge Koh issued a sweeping order under Sherman Act 1 and 2 that these practices were illegal. She said, Qualcomm, you got to change your business model. You got to renegotiate all 400 of your licenses. I mean, this was a death knell, and I'll give Qualcomm credit. They knew that it was going to be a tough slug in the district court. They tried the case anyway, and we lost. And a sweeping order, and heads down. The Ninth Circuit stayed the order, and the Ninth Circuit reversed it completely. What's remarkable is it really is sort of a paean to the importance of innovation in our district, in our state, in our country. And what the Ninth Circuit held was that these practices were pro-competitive, even hyper-competitive, because they allowed innovation to thrive, even though they may have increased the ultimate cost to the consumer of a handset. And the language of the Ninth Circuit is quite remarkable. And this is where I think Tom was alluding to, Sherman Act and Cartwright Act may devolve. Under the Sherman Act, reducing consumer choice or increasing prices are fully consistent with a free competitive market and do not establish injury to competition, to competitors. Novel business practices, especially in the tech markets, should not be presumed unreasonable without elaborate inquiry. And so, with respect to licensing competitors, the court said, you don't have to do that. You can choose who you do business with. You don't want to license a competitor because that's not lucrative? Don't do it. And so the federal side of this, the Sherman Act side of this, was really all about the act is intended to protect competition, not customers, not customers. Now, this case came back because the class was still going. Judge Koh went up to the Ninth Circuit. Judge Corley picked the case up. So we still had it here. And the plaintiffs amended their complaint. They got rid of all the Sherman Act and they came in with the Cartwright Act. And they said, oh, the Cartwright Act is so different. Oh, the Cartwright Act allows all this, declares all this stuff illegal. And Judge Corley wrote a very, very thoughtful opinion in which she said the Cartwright Act is broader and deeper than the Sherman Act. The Cartwright Act's principal goal is preserving consumer welfare. A claim dismissed under the Sherman Act can thrive under the Cartwright Act. Now, ultimately, the plaintiffs lost because they didn't have the evidence to show that there had been any real impact on prices. And so the case failed on summary judgment. But I raise it to say that the Ninth Circuit opinion, which is kind of and the FTC decided not to seek cert, so that opinion stands, is a great opinion outlining this hard to define line between innovation and unfair practices. And basically it's saying that as long you can kick living daylights out of your competitors, that's what we're looking for. If that allows you to get a monopoly and charge more prices, God bless you, because that's part of competition too. I think the Cartwright Act is different. It'll be probably interpreted differently. I know that they're trying in Sacramento to amend the Cartwright Act to make it even more liberal for plaintiffs. We'll see if that goes through. I don't know. But That's a great case, and Judge Corley's opinion, which was issued about a year ago, is a really good thing to take a look at on this distinction between Sherman Act and Cartwright Act. So that's the FTC Qualcomm Lee.
Thank you so much, Bob. I think we're just 3 minutes over, but maybe time for one question, or if anybody in the audience would like to. Wow, a room full of lawyers and no one wants to talk.
They're ready to drink.
Well, then, thank you. Can we thank the panel very much for their comment? And you can grill them outside over drinks.